I'm also joined right now by Vikas Singh, Senior Advocate, Supreme Court and former Additional Solicitor General of India. So my first question, stems from the fact that the top court could have continued to hear the case or transfer it to a high court, but didn't do so. They did pass an injunction. The fact that they have found merit to stay status quo or pass an injunction on two very controversial provisions of the law. Do you think that somewhere down the line the court has clearly seen merit in the petitioner's case against the Waqf law?
So there are definitely issues being raised by the petitioners, which the Supreme Court feels need consideration. As of now, they have not passed any interim order. They have kept the matter for the reply of the Union of India. And it is only the Union of India is not able to give a satisfactory answer to the clauses, referred to by the petitioners, that a question of passing an interim order will arise. So far, they have actually heard only the petitioners, and they have not seen the entire act, and they have not seen the scheme of the act. Probably once they see the whole scheme, then a stay, the question of stay may not arise.
But the sheer fact, Mr. Singh, that the court today saw merit in at least passing an injunction on two of the most, contentious, controversial provisions, be it by Waqf by user or non-Muslims on boards. And, they've made that clear that the government can't act on it and their status quo. If that continues, at least right now it's only interim till the next hearing, which is on the 5th of May. But if that continues, somewhere down the line, do you think the law will be defanged?
So according to me, there are basically 2 or 3 contentious clauses which the Supreme Court is actually examining. One is the participation of non-Muslims in the Waqf board. Now that government has taken a stand that there will be only 2 non-Muslims apart from the ex officio members. Although there is no clarity in the act, it would have been better if it had been spelt out, in the act itself, that there will be maximum of 2 non-Muslim members in the board. But this can be read down by the Supreme Court by saying that 2 non-Muslim will be the maximum 2 non-Muslims, and it will not exceed 2 people of the not subscribing to the Islam. The other contentious clause is with regard to the survey by the officer senior in rank to the collector when the government claims it to be government land, Waqf land to be government land. The objectionable clause which the Supreme Court is finding so far is that while the survey is going on, the rights of the Waqf will be suspended. It will be not deemed to be Waqf during the period of survey, which sounds a little, odd, because whatever decision should happen after the survey is over, not at the time when the survey has just started. So that is the other clause which they are considering of, tinkering with. And lastly, the Waqf by user is something which they are worried that why this is being done away with. And in my view, that is not really a problematic clause because Waqf by user, past Waqf by user is being acknowledged in this act, and those Waqfs will remain. It's only the new Waqfs which will be created post this act has coming into force will not be by Waqf by user, they will be only by a deed, which according to me is to the benefit of the person who's creating the Waqf, because by keeping a Waqf by user and without spelling out the terms of the Waqf, you are actually creating uncertainty for the future. So it's better to have it on a deed and get that deed registered with the board. Because really speaking, even though the Muslim law may permit Waqf by user, the Article 26 permits the state to make a law for the administration of these properties. And while administering the property, if the state feels that having a document with regard to fresh Waqf, not the earlier ones will not have to be registered. I mean, they will continue to remain if they've already been registered under the earlier act.
But Mr. Singh, the fact, on what you touched on, where you say it will not have an issue in your view, which is the Waqf by user provision. But on that argument, Abhishek Manu Singhvi in court has argued that, 4 lakh of the 8 lakh existing Waqf property, lakh hectares, are perhaps by Waqf users only, and that the newly induced provisions makes them non-existent by just one stroke of a pen.
No, that's not correct. So that's a wrong interpretation. It's a wrong argument. That's why the reading of the act will have to be seen. It only says that henceforth Waqf by user will not be done. And all Waqfs prior to this act, even by user, will be allowed to continue, and there will be no impediment in those Waqfs, and their status will not in any manner be diluted, or there will be no takeover of these Waqfs. So there is no question. It's a complete misreading of the act. Only thing which they are ultimately wanting to argue is that Waqf by user henceforth also should be permitted. And they say, as per Islam, this is something which is permissible. But I agree that it is permissible as per Islam. But the state, when it has the right to make a law, it can always make a law for registration or for a document to be created of a Waqf by user. Like, for instance, in a family settlement, there could be an oral family settlement, but it has to be ultimately recorded in the form of a yadasht. And then only among Hindus that family settlement becomes enforceable by law. So I don't see any impediment or any real big legal lacunae in asking a Waqf by user to record record in a document the terms of the user and and how the Waqf will operate in the days to come. So I personally feel that is not something which is an objectionable clause. It is only being sort of blown out of proportion by the petitioner side.
Right. Mr. Singh, also the centre has now 7 days to file its own reply. And because, it is a politically surcharged case, we've seen that many of the petitioners are political parties. A lot of people and these political parties are calling it a setback for the centre. How would you react to that?
No, so asking to file a reply can never be considered a setback. I mean, the earlier Waqf Acts were also challenged and they were pending in the High Court. Now Supreme Court wants to examine the whole thing here. Probably will transfer the ones which are pending in the High Court also. And while examining a statute, the other side definitely has a right to file its reply. And asking for a short reply before passing an interim order is something which is quite usual. It can't be said to be a setback under any circumstances. Because filing a right to file a reply, there is a right with the court to pass an ex parte order. They could have passed an ex parte interim order also. So they have probably felt that taking a reply will be better for them to understand what exactly are the provisions of the act and how they are to be interpreted. For instance, in the reply, supposing if the central government were to say on affidavit that the board will not have more than 2 people as non-Muslims. Now, if that is recorded on the affidavit, the section can be read down on the basis of the affidavit, and that apprehension of the petitioners will automatically be satisfied. So I don't see this to be a setback at all for asking them to file a reply.
Mr. Singh, do you think it's going to be now a very long, protracted, prolonged case and battle, because the court has said it will be hearing only 5 main petitions, but given that almost all clauses, all provisions are being challenged by the petitioners, do you think a final decision is a long way away?
No, so obviously on the next date, final decision is not going to happen. So they'll be fix up a date for hearing. It may take 6 months, it may take 1 year. That will depend on the priority which the Supreme Court attaches after the interim order, whatever if it is they're proposing to pass. But if they feel that if they pass some kind of an interim order which protects both the sides, then there may not really be any urgency to hear the matter. So a lot will depend on what happens on the next date of hearing. If no interim order is granted, then I'm sure they will post the matter for hearing very soon and decide the matter also expeditiously. But if they pass some kind of a working arrangement, pass an order which can be said to be some kind of a working arrangement, then there may not be any necessity to hear the matter urgently. And then they may hear it on its turn, which may take time. So a lot will
But Mr.
depend on
Singh,
what happens on the next day.
right. Just one final question, Mr. Singh. There's a lot of outrage, or shall I say concern, being expressed by people who support the bill. They claim that this was a bill that was passed after a lot of consultation, after a lot of discussion, debate. Stakeholders were involved. The supporters of the bill are asking if it would be right for the court to grant any interim stay at all. This is what a lot of people are asking who support the bill.
So, court has not granted any stay so far. Court is merely hearing the parties at the moment. So, why are you, judging what the court is going to do on the next date of hearing? For all you know, if the central government is able to satisfy the court about the misgivings that have been created by the petitioners, there would be no questions of any stay in this matter. So, I don't see why should we perceive this hearing as if the court has already taken a call to pass an interim order. So I don't think there is any such apprehension.
Okay. Well, thank you. Thank you for taking out the time and joining us this evening, Mr. Vikas Singh. We're going to let it be at that, viewers, because right now it's just status quo. There's no real development at that. You can call it interim relief, interim setback, but just focus on the word interim. The next hearing on the 5th of May. One thing there is clarity on. Yesterday, the top court of the country has said that we could hand over the case to the High Court. They're not going to do that because they've already started, passing observations, so they are hearing the case. It's going to be heard by the Supreme Court itself. That is at least something that we know right now.